Hello dear viewers, welcome again to the series of lectures. Today we will discuss about offer, and after this lecture you shall be able to know the meaning of offer, communication of offer, communication when complete, intention to create legal relationship, test of contractual intention, and classification of offer. Now let's start with introduction. A proposal or promise backed by legal consideration is an agreement. If legally enforceable, it becomes a contract. The starting point of this chain is a proposal or promise. For the formation of a contract, there must be at least two persons to make a contract. A person to make the proposal and the other person to accept it. A proposal to be valid must contain the following essential elements. That is, every proposal must be communicated. It must be made with a view to create legal relations and must be certain and definite. Now, definition of offer. The word offer and the word proposal mean one and the same thing and therefore are used interchangeably. In terms of Section 2A of the Act, a person is said to make a proposal when he signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence. The willingness to do or to abstain from doing something is that the offer may be made with a view to obtaining the assent of the other party. It must be appreciated that the doing an act and not doing an act both have the same effect in the eyes of the law, though one is a positive act and other is a negative act. Hence, there are two important ingredients to an offer. Firstly, it must be expressions of willingness to do or to abstain from doing an act. Secondly, the willingness must be expressed with a view to obtain the assent of the other party to whom the offer is made. This can be illustrated as follows. Where A offers to sell his car to B, it conveys his willingness to do an act. Though his offer, not only willingness, is being conveyed, but also an intention to obtain the assent can be seen. The offer is the starting point of agreement. The person who makes the proposal is called the offerer or promiser. The person whom accepts it is called the offeree or proposee. And when he accepted it, he is called the promisee. Thus, the person making the offer is called the promiser, and the person accepting the proposal is called the promisee. Now let's discuss communication of offer. Offer must be communicated to the offeree. A proposal or offer may be communicated in any way which has the effect of laying before the offeree the willingness to do or to abstain. It may be done by words of mouth or by writing or even by conduct. As the first part of the definition of proposal lays emphasis upon the requirement that the process of making a proposal is completed by the act of communicating it to other party. According to Section 3, a proposal may be communicated in any way which has the effect of communicating it to the offeree, and according to Section 9, the communication of offer may be either express or implied. Expressed by words of mouth or by writing and implied by conduct. In case of T. Jayaram Naidu versus Yashod AIR 2008, an oral agreement for sale is valid and enforced. Proving such agreement may be difficult, but when proved valid. The definition requires that the offer should be signified. To signify means to communicate to the other party. The process of making a proposal is completed by the act of communicating it to the other party. Section 3 recognizes the mode of communication. Words are not the only medium of expression. Conduct may often convey as clearly as words. A promise or an assent to a proposed promise, an offer which is expressed by conduct, is an implied offer, and the one which is expressed by words, written or spoken, is called as express offer. Consuming eatables at a self-service restaurant or stepping into an omnibus both create implied promises to pay for the benefits enjoyed. Similarly, a bid at an auction is an implied offer to buy. An illustration of implied promise to pay or contract arising impliedly from conduct is the case of Upton Rural District Council versus Powell, 1942. A fire broke out in the defendant's farm. He was under the impression that he was entitled to the free service of Upton and therefore summoned the fire brigade to put out the fire. But it turned out that the defendant's farm was not within the free service zone of the Upton. The Upton claimed payment or compensation for the service rendered. The defendant contended that there was no express promise to pay or contract. The court rejected his contention and allows the compensation or value of services and held that the services were rendered on an implied promise to pay. Section 9 was applied by the Supreme Court in the case of Haji Muhammad Ishaq versus Muhammad Iqbal, 1978, where on the orders of third person certain goods were supplied by the plaintiff to the defendants. The defendants unerringly accepted the goods, paid a part of the price. The defendants refused to pay on the ground that there was no express contract with the plaintiffs. The court held that the circumstances and the conduct of the parties clearly shows that a direct contract, which in law is called implied contract by conduct, was brought about between them. In Sultan Sadiq versus Sanjay Raj Subha, AIR 2004, the Supreme Court observed that a contract of service in the absence of any statute is also governed by the provision of Contract Act. It is therefore not correct to contend that an order of appointment is not required to be communicated for making a valid contract of service. It is therefore absolutely necessary to communicate such an order to the appointee by the state, and acceptance thereof, whether expressly or by necessary implication, was also required. Unless this is done, contractual relation will not come into being. Now, what happens when communication is complete? It is clear from Section 3 that an offer must be communicated to the offeree before it can be accepted. A proposal can be accepted only when it comes to the knowledge of the person to whom it is intended to be made. Section 4 therefore provides that the communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. In most cases, this is self-evident, but where a reward has been announced, it gives rise to the question whether a person who has performed the necessary action can claim the reward even if he is unaware that it had been offered. In S. Butel and Company versus State Forest Corporation, AIR 2002, the Himachal Pradesh High Court reiterated an already established legal principle that an offer may be accepted either by expressing words or positive conduct. In the instant case, the defendant asked the plaintiff to proceed the case without any reservation, even after receiving the letter from the plaintiff containing the terms of professional fee. It was held that it amounted to acceptance of contract between the parties. According to Section 8 of the Contract Act 1872, performance of the conditions of a proposal or the acceptance of any consideration for reciprocal promise which may be offered with the proposal is an acceptance of a proposal. The communication of acceptance is not necessary in such cases. The expression concluded contract came for consideration again in Union of India versus Pico Private Limited AIR 2003. It was held that when the offer has been communicated to the offeree and accepted by him and the same has been conveyed to the offeree, the contract stands concluded. There is then no merit in contending that acceptor did not accept arbitration clause contained in the offer. Again in Vipab Kumar versus Shrimati Asha Lata Ahuja AIR 2009, a concluded contract will not come into existence unless there is an acceptance of an offer, and suit for damages is maintainable only when there is a concluded contract. Let's now talk about the intention to create legal relationship. Salmon observed that the law of contract is not the whole law of agreements, nor is it the whole law of obligation. In English law, it is a settled principle that in contract there must be legal relation, but there is no provision in the Indian Contract Act, nor has there been any reported decision requiring that an offer or its acceptance should be made with the intention of creating legal relations. Every agreement, however, is not a contract. Agreement may relate to social matters and may not be intended to have any legal consequences. It is only when the agreement is intended to be attended by legal consequences that a contract can arise. Thus, in Balfour versus Balfour, AIR 1919, defendant was a civil servant stationed in Ceylon. His wife alleged that while they were both in England on leave, and when it had become clear that she could not accompany him abroad because of her health, he had promised to pay her rupees 30 per month as maintained during that time. They were thus living apart. The husband failed to pay and she sued for breach of this agreement. The wife attempted to enforce this promise, but action failed for two reasons. First, she had not provided any consideration, and the parties did not intend the agreement to be legally binding. On the second ground alone, most domestic agreements between husband and wife are not contracts. Atkin L.J. said, "Those agreements are all even though these may be what, as between other parties, would constitute consideration for the agreement. They are not contracts because the parties did not intend that they should be attended by legal consequences. Agreements such as these are outside the realm of contracts altogether." The Balfour principle applies to dealings between other relations as father and son and daughter and mother. As in case of Jones versus Paddowayton, AIR 1969. This does not, however, mean that in family or personal matters there cannot be a legally binding contract. All that the law requires is that the parties must intend legal consequences. In MC Grigor versus MC Grigor, AIR 1888, there was a binding agreement between a husband and wife. to withdraw their complaints under an agreement, by which the husband promised to pay her an allowance and to refrain from pledging his credit. The agreement was held to be a binding contract. Similarly, in Merit versus Merit, AIR 1970, the husband and wife were the joint owners of a house, which was the subject matter of mortgage to a building society. The husband left the matrimonial home to live with another woman. At that time, at the instance of the wife, the husband signed a note saying that the wife will pay all the outstanding amount in respect of the house, and in return, the husband will transfer the property into her sole ownership. It was held that in this case it was clear that the parties intend to create legal relationship and therefore the husband was bound by the contract. All that the law requires is that the parties must intend legal consequences. For example, an agreement between the relatives to share a house property has been held to be Chandrakant versus CIT, AIR 1992, that a contract of any kind, including that of a partnership between the members of undivided Hindu family, is quite possible. Now let's discuss test of contractual intention. Objectively and not subjectively is the test of contractual intention. What matters is not what the parties had in mind, but what a reasonable man would think in the circumstance their intention to be. Following this principle, the Supreme Court in CWT versus Abdul Hussain AIR 1988 observed, where one partner has lent a large sum of money to the other to be utilized as capital in the partnership firm, the transaction is of commercial nature. The presumption is that the legal obligations are intended. The onus is on the party asserting the absence of legal obligation, and the test is not subjective but objective one. Since there is no provision in the Indian Contract Act 1872 that an offer and acceptance should be made with the intention of creating legal relationship, the Supreme Court in Abdul Hussain's case has therefore expressed its reservation about the need of contract, as it is still an open question whether the requirement of contractual intention would be applicable within the framework of Indian Contract Act. Agreements regulating social relations. It follows almost as a matter of course that the parties do not intend legal consequences to follow. In the case of agreement regulating business relation, it equally follows almost as a matter of course that the parties intend legal consequences to follow. Even in business matters, parties may intend to rely on each other's good faith and not on the courts. The law of contracts deal with such agreements as can create obligations. After all this, the important thing is that proposal must be certain and definite. The terms of the proposal must be certain and definite. It should not be so vague so as to prevent the formation of contract. Section 29 of the Indian Contract Act provides agreements, the meaning of which is uncertain or capable of being made certain is void. For example, A agrees to sell to B 100 tons of oil. There is nothing whatever to show what kind of oil was intended. The agreement is void for uncertainty. In case of Davies versus Davies, it has been held it is the function of the courts of law to interpret contract, to say whether a contract is or is not reasonable, to say whether it is or is not void. But it is not the duty of court to make contract between the parties. Thus, a court can only construe a contract and not make a contract. Now, let's talk about the classification of offer. Offer can be classified as general offer, special or specific offer, cross offer, counter offer, standing or open or continuing offer. Now let us examine each one of them. First, general offer. It is an offer made to public at large with or without any time limit. In terms of Section 8 of the Act, anyone performing the condition of the offer can be considered to have accepted the offer. In Indian Contract Act, Section 8 says, performance of the condition of a proposal or acceptance of any consideration for a reciprocal promise which may be offered with the proposal is acceptance of the proposal. Thus, there may be general offer or an offer made to the whole world, but it becomes a contract only when specific person comes forward and accepts it or performs the conditions of offer. Supreme Court in M.S. Bhagwati Prasad Kumar versus Union of India AIR 2006 clarified the legal position. The Supreme Court observed, Section 8 of the Indian Contract Act provides for acceptance by performing conditions of a proposal. Thus, an offeree cannot be permitted to change his mind after the unequivocal acceptance of the offer. Second one is special or specific offer. Where an offer is made to a particular and specified person, it is a specific. Only that person can accept such specific offer, as it is special and exclusive to him. Bolton versus Jones, 1857, Jones used to have business dealings with Brocklehurst. He sends an order to Brocklehurst for the purchase of certain goods. By the time the order reached Brocklehurst, he sold his business to Bolton. Bolton, receiving the order, sent all goods to Jones as per the order, without informing Jones of the changing of the hands of business. When Jones learned that the goods were not supplied by Brocklehurst, he refused to pay for the goods. His contention was that he had never placed an order to Bolton, the offer being made to Brocklehurst, and therefore had no intention to make a contract with Bolton. Court held that Jones is not liable to pay. Third is cross or counter offer. As per Section 2B, when a person to whom proposal is made signifies his assent, the proposal is said to be accepted. Thus, assent can be only to a proposal. If there was no proposal, question of its acceptance cannot arise. In Tim versus Hoffman and Company, 1873, A wrote to B indicating his willingness to sell 800 tons of iron at 69 sheets per ton. On the same day, B wrote to A offering to buy 800 tons of iron at the same rate of 69 sheets per ton. Two letters crossed each other in post. B brought an action against A for the supply of iron, contending that a valid contract had been created between the two parties. It was held that in this case there were only two cross offers, and the offer of neither of the parties having been accepted by the other, there was no contract which could be enforced. Fourth one is counter offer. Upon receipt of an offer from an offerer, if the offeree, instead of accepting it straightaway, imposes conditions which have the effect of modifying or varying the offer, he is said to have made an counter offer. Counter offer amounts to rejection of original offer, so it is simply an offer given in response to an offer. For instance, seller offers to sell his house for rupees 25,000 to be paid in 60 days. Buyer receives the offer and gave seller a counter offer of rupees 20,000 payable in 45 days. Here the original offer is dead despite the shorter time for payment since the price is lower. Seller then can choose to accept at rupees 20,000, counter again at some compromise price, reject the counter offer or let it expire. In Food Corporation of India versus Ramkesh Yadav, AIR 2007, a conditional offer has to be accepted or rejected with a counter offer. The offeree cannot accept a part of it. And the last offer is standing or open or continuing offer. An offer which is made to public at large, and if it is kept open for public acceptance for a certain period of time, it is known as standing or continuing or open offer. For instance, an offer to supply 2000 bags of rice from 1st January to 31st December in accordance with the order, which may be placed from time to time, is a standing offer, as and when the orders are placed that amounts to acceptance of the offer to that extent. So, if the order for the supply of 100 bags of rice is placed on 25th July, there is acceptance of the offer to that extent and the offerer becomes bound to supply those bags of rice. So far remaining quantity is concerned, this offer can be revoked just like any other offer. Two offers which are similar in all respect made by two parties to each other in ignorance of each other's offer are known as cross offer. Cross offer does not amount to acceptance of one's offer by the other, and as such no contract is concluded. For example, A writes a letter to B. If he is ready to pay rupees 1 crore, then B will sell off his flat to A. Without knowing about said offer, B writes to A if he is ready to accept rupees 1 crore as a price money for flat. Then title deed may be sent to his advocate. Being a cross offer, no contract is concluded. So that was all for today. Hope you have understood all about offer. We'll see you soon with a new topic. Till then, take care of yourself. Goodbye.